Welcome to Casa Academy Chapter 3, Part 3, where we will cover real estate license law and commission rules. I am absolutely thrilled to dive into this today because, honestly, we're tackling a topic that is pure gold for your foundational real estate knowledge. We're going to clear up a lot of those common misconceptions and really break down the exact rules governing who you can work for and how your license actually functions out there in the real world.
Now, right out of the gate, I want to just acknowledge something. The whole difference between group licenses and multiple licenses, it can be a little confusing for students at first. It's kind of one of those classic stumbling blocks. But tying directly into our goal of preparing you for success, this distinction is absolutely essential to master for your state exam. The good news is, once you understand exactly who each of these terms applies to, the difference becomes crystal clear and so much easier to remember. And that is exactly what we're going to achieve today.
So here's our roadmap. We'll start with number 1, the one-employer rule. Then, number 2, group licenses explained. Number 3, multiple licenses. Number 4, referral agreements. And finally, number 5, an exam prep recap.
Let's dive right into Section 1, the one-employer rule, which is really the foundation of licensing. Okay, so the absolutely crucial point here is this. As a sales associate, you may only be registered with and work for one single employer at a time, period. You can't just freelance around town for 5 different brokerages. It doesn't work that way. Your single employer has to be either a licensed real estate broker or an owner-developer. Whichever path you choose, that employer is legally responsible for supervising your activities. They're the ones helping to ensure that you're fully complying with all Florida real estate laws and commission rules. So one associate, one employer. Keep that rule locked in your mind.
Moving right along to Section 2, Group Licenses Explained, specifically looking at owner-developers.
Which naturally brings us to a super common question. What exactly is a group license? Well, to really understand the answer, we have to pivot our lesson a bit into the specific legal structures of large development companies. You see, a standard broker typically sells property on behalf of other people, right? But an owner-developer, think of a massive residential builder, is actually selling property that the company itself owns. So let's look at the main problem these developers run into. In Step 1, a large developer often builds and owns several totally different communities. Maybe they have a sprawling golf course community on one side of town and a sleek high-rise condo on the other. For Step 2, they will usually incorporate each of these communities as completely separate legal entities. Now, why do that? Well, Step 3 gives us the answer. It dramatically limits their liability. It keeps the day-to-day operations and the financial risks of one development totally isolated from another. But here's the huge hurdle. If every single community is a different legal entity, how on earth can an associate legally sell homes in all of them without violating that strict one-employer rule we just talked about?
And this brings us to the brilliant solution, the group license. Now, a group license is not actually a completely separate, brand new real estate license. It's really just a form of registration. It allows a sales associate or a broker associate who is employed by an owner-developer to go ahead and work across all those multiple related entities as long as they are owned by the exact same parent company. So it perfectly solves the developer's legal problem while keeping the associate entirely in line with the one-employer rule.
Let's pull back the curtain and look at how this happens behind the scenes. Imagine the division of real estate is processing a registration file for this setup, and they assign it the number 784588. This single file number acts like a master key. In the state's database, that specific group registration file number securely connects the dots between all those various corporate entities owned by that same parent developer.
So let's really cement this rule. No matter how many different communities the associate is driving to each week to sell homes, they are still employed and paid by just one single employer, the parent owner-developer. When you see the term group license pop up on your exam, I want you to immediately think of this formula. Group license equals a sales associate working for an owner-developer.
All right, jumping into Section 3, multiple licenses. And note the very important subtitle here, for brokers only. This is a crucial distinction to remember. Multiple licenses apply exclusively to brokers, not to sales associates. As an associate, you simply cannot hold multiple licenses, purely because of that strict one-employer rule we established earlier. Before we break down exactly how brokers utilize this unique exception, please note that your verification code is 3265998. Okay, let's look at a practical, real-world example of how a broker operates a bit differently under Florida law.
Let's look at a specific scenario. Suppose Cindy is a licensed broker. First, she opens her own brokerage company called ABC Realty, and she acts as the broker of record for that specific company. A little bit later down the line, Cindy decides she wants to expand her empire. So she purchases a completely separate property management company. But instead of just making it a branch of ABC Realty, she wants it to be an entirely independent business with its own unique name and its own license. Well, because Cindy is a broker, the law allows her to legally serve as the broker of record for both of these separate companies at the exact same time. This is literally what multiple licenses means. She holds one license to be the broker for ABC Realty and a multiple license to be the broker for the property management firm.
But hey, here is a massive warning I have for you as a student. While Cindy the broker can totally manage multiple businesses, provided of course she doesn't create a conflict of interest or harm the public, her associates absolutely cannot. Let's say you're an associate hired by Cindy over at ABC Real Estate. You cannot split your week spending Monday and Tuesdays selling houses for ABC Real Estate and then Wednesday and Thursday leasing apartments for her independent property management company. Each company is a legally separate entity, and you, the associate, remain strictly anchored to the one-employer rule.
Which brings us to Section 4, referral agreements, and how these separate entities are working together.
Distinctly separate businesses can actually legally interact without ever violating the strict one-employer rule, and they do this through formal referral agreements. Let's go back to our previous example with Cindy. Suppose an associate at ABC Realty sells a fantastic duplex investment property to a client. Naturally, that client now needs someone to manage the renters. The associate can legally refer that client right over to Cindy's completely separate property management company.
Now let's walk through the exact legal flow of how the compensation actually works in this scenario, because this flow is vital. Step 1, the client needs management services and goes over to the referred company. Step 2, because there is a formal, documented referral agreement in place, the property management company pays a referral fee. But notice exactly where that fee goes. It goes directly to ABC Realty, the brokerage. Then, Step 3, ABC Realty compensates the associate according to whatever their internal brokerage agreement is. Do you see how brilliantly that works? The money safely travels back through the associate's actual single employer. The one-employer rule remains completely unbroken.
All right, finally, let's wrap this up with Section 5, our exam prep recap and key takeaways.
I really want to drive home this ultimate contrast so these definitions never blur together in your mind when you're sitting down for that state test. First, think about the group license. Who is it for? Associates. Who is the employer? An owner-developer. It allows the associate to sell across multiple related entities while keeping just one employer. Now contrast that with multiple licenses. Who is this for? Brokers. Why? To allow them to be the broker of record for multiple, distinctly separate businesses. Memorize these specific distinct differences, and you will absolutely nail these questions on your exam.
And that brings us to the end of our explainer today. So I want to leave you with this final, somewhat provocative thought. Which license will you hold on your real estate journey? Will you find yourself thriving under a group license, selling beautiful new construction for a major owner-developer? Or will you eventually become a broker yourself, holding multiple licenses as you build an absolute empire of separate real estate businesses? The choice is entirely up to you. Keep studying, keep focused, and I'll see you in the next chapter.